All right, let's go to chapter 16. As I told you on the state exam, out of 150 questions on the state exam, 45 questions, most of them are going to be from chapter 16, but 11 and 13 as well. 16, 11, and 13, but mostly 16. So this deals with Illinois real estate licensing laws. Now, the first paragraph, you like you to highlight the first and second paragraph, put X's by them. Now, every state has real estate licensing laws. I know I mentioned this before. The purpose of Illinois real estate licensing laws is for the protection of the public, not us, for the protection of the public. So now I want you to skip down a couple paragraphs where it says the real estate industry in Illinois is regulated by IDFPR, which is a DPR is a branch of that. I'm going to explain that in just a moment. Well, I'm going to explain it right now. Let me explain something. Now, we are licensed by what's called IDFPR. IDFPR stands for Illinois Department of Financial and Professional Regulation. This is the agency that not only regulates us, licensees, but they also, there's over 300 licenses that falls under IDFPR. Attorneys are licensed by them, doctors, nurses, hairstylists, pawn shops, roofers, just about anyone that, general contractors, anyone that needs a license, they're licensed under IDFPR. But the real estate portion of it has grown quite large. So they created a separate division under IDFPR called the DPR, which stands for Division of Professional Regulation. Now, both of these are referred to as the department. We call them the department. You don't have to, you can say DPR or IDFPR, however you want. We refer them as the department. So getting back to the textbook. In the next paragraph, it says the department is responsible for administering and enforcing the Real Estate License Act of 2000. I don't know if maybe you should put an X by that paragraph. And actually, I don't know if I told you, put the paragraph above where it says the real estate industry in Illinois is regulated by the DPR, which is a branch under the IDFPR, which is referred to as the department. Now, the department, besides administering the License Act of 2000, they're responsible for all the real estate brokers, managing brokers, residential leasing agent, real estate corporation partnerships, LLCs, real estate schools, real estate instructors. We all fall under the DPR or the department. The next paragraph, the first couple of lines highlight, put X by that. The department promulgates rules for the act, implementation, and for the enforcement. These are referred to as the rules. Now, let's go on to the next page. At the very top, I would say the first 4 lines. The department, through the DPR, has the authority to administer the License Act of 2000, empowered to issue the rules, regulations, implement, and interpret the act. So people have a full understanding. Now, some of the responsibilities of the department, you can highlight, put an X by the next 4 bullets. The department is responsible for administrative activities such as conducting license exams, issuing and renewing license, preparing all forms, and collecting fees. Now, the department has additional functions, so highlight put X by the next three bullets. They conduct hearings, they impose penalties, and they restore suspended or revoked licenses. Now, there is a commissioner of IDFPR that's appointed by the governor. So the governor appoints the commissioner. The governor also appoints what's called a real estate coordinator and also a deputy coordinator. Now, as some of the duties of the real estate coordinator, there are 6 bullets there. I like you can highlight those 6 bullets. Only put an X by the second bullet. One of the duties of the coordinator that's appointed by the governor is to be a direct liaison between the department, the real estate profession, real estate organizations, and association. Now, the next section, real estate administration and disciplinary board. I want you to highlight the last 2 lines of this page and the first 2 lines of 346. There is a disciplinary board. If anyone's been aggrieved by real estate licensee, they can file a complaint with the disciplinary board. Now, the board will investigate any written verifiable complaint against any licensee, whether it comes from the general public or maybe another real estate licensee. Now, here's what I need you to know. Composition of the board. I want you to highlight and put an X by it. This disciplinary board is made up of 15 members. All 15 members must be U.S. citizens and Illinois residents for at least 6 years. Of the 15, the first bullet, put X by that, 12 of them must be licensed as either managing brokers or brokers for at least 10 years. Of the 12, 2 of them must also have a pre-licensing instructor's license. The next bullet, 3 members of the board are from the general public, meaning they're not licensed, their immediate family is not licensed, they have nothing to do with real estate. That's the composition of the board. I want you to be a little bit familiar with the brand new change, but this one hit the exam fairly quick. So, all right, the bottom of this page, 346, obtaining and keeping a real estate license. Who needs to be licensed? States in here, it is illegal, and put X by this one, for anyone to act as a broker, managing broker, sponsoring broker, residential leasing agent without a real estate license issued by the department. Now, you need a license to perform any of these activities, all these bullets. You can highlight all of them, go over all of them. Basically, you need a real estate license. If you're going to sell, exchange, purchase, lease, trade, negotiate for compensation or expectation of compensation, you must have a real estate license. Now, here's another new law that just came up. This is called the wholesaling law. Wholesaling is when someone buys property and then they flip it and sell it to someone else. Now, in order to do so, you must have a real estate license or you must hire someone that has a real estate license. Okay, wholesaling is something new that just came up. So, I buy a property for $500,000. Before I close on it, I sold it to someone else for $700,000. That's wholesaling. That's an example. Not quite the same as flipping, though. Now, Unlicensed Agent Act. This is a new one, too. Any person who is found working or acting as a managing broker, residential leasing agent, or holding themselves as a licensed sponsoring broker, managing broker, residential leasing agent without an active license is guilty of a Class A misdemeanor. That part you don't have to remember, but they can refuse to issue your license and they can fine you. Even if you're not licensed, IDFPR has a right to fine you. if you practice real estate without a license. Up to $25,000, by the way. License requirement exemption. The following people do not need a license in order to sell real estate, okay? I like you to highlight, there should be 7 bullets. 1, 2, 3, 4, 5, 6, 7. Yeah. I'd like you to highlight all 7 bullets. I'm going to go over all of them. The last 3, I want you to put an X by to highlight all of them. The following people do not need a license in order to sell real estate. Owner of a property. You own your own property. You can lease your own property. You can sell your own property. You do not need a license in order to do so. The second bullet, if you're acting under a duly executed recorded power of attorney. If I sign a power of attorney over to you, you can sign my name to anything, even sell my property. The next bullet, services rendered by attorney at law while performing duties as a lawyer, they do not need a license. The next bullet, a person acting as a receiver, trustee in a bankruptcy, administrator, executor, or guardian, or you're acting under a court order of a will, you do not need a license. You had a relative of yours that died. You're the executor of their estate. You have to dispose of their property. You do not need a license to do so. You're working under the order of a will, which is under the courts. Now, the next 3 bullets, I need you to put X's by them. I want you to understand these. A resident property manager. In order to manage property for someone else, you must have a managing broker's license. But if you live in a building that you manage, you don't have to be licensed. And you're able to manage the one building that you're living in. You can't manage anything that you're not living in, but you could manage the one building that you're living in. The next bullet, you have an X by this one. State and federal officials or officers, meaning this. If you work for the state of Illinois or you work for the federal government and your job is to acquire and dispose of real estate, you do not need a license in order to do so, but only in the performance of your job. Doesn't mean on your days off you can sell your neighbor's home. Now, again, this is only federal and state of Illinois, not city of Chicago, not Cook County. So let's say you work for the state of Illinois Conservation Department. Your job is to acquire and dispose of parkland. You do not need a license in order to do so. But again, only in the performance of your job. You work for the federal government. Your job is to acquire and dispose of post office sites. That's your job. You do not need a license to do so. But again, only in the performance of your job. If you work for the city of Chicago and you have to acquire land, or you work for Chicago Board of Education and dispose of schools or something, well, you have to have a license or you have to hire someone that's licensed. So it's only state and federal officers. Now, this last one I want you to put an X by as well. Oh, there's actually another one. I didn't see the other one. So if you are a tenant in a building and the landlord asks you as a tenant, hey, I got an empty apartment. If you know someone, I'll pay you a referral fee. You could collect a referral fee. You cannot refer more than 3 tenants to the building in any 12-month period, and compensation cannot exceed more than $5,000. So I own an apartment building, you're a tenant in there, says, I got an empty apartment coming up. You have anyone, if you know of anyone that's looking to rent, I'll give you a referral fee. I can't do more than 3 in a 12-month period, and they can never total more than $5,000. Now this hotel operator, that's a new one. I forgot about this one though. It says a hotel operator who's registered with Illinois Department of Revenue and pays taxes under Hotel Operators Occupation Tax Act and rents a room or rooms in a hotel that's defined as a Hotel Operators Occupation Tax Act for a period of not more than 30 consecutive days, not more than 60 days in the calendar year. or a person who participates in online marketing. Oh man, I know I did not write this paragraph because I would know it. Okay, they said that employee will be exempt. I never saw hotel operators, new laws, so don't even worry about it. Those last three that I told you put X's by, make sure you do know that. Now, okay, this very next paragraph here, highlight, put an X by. Should a sponsoring broker's license be revoked or rendered inactive, all licensees under that sponsoring broker are considered inactive as well. So let's say all of you out there, all 19 of you, work for me. I'm your sponsoring broker. You are brokers. Something happens to my license. My license is revoked or it's inactive. You are still licensed, but your license is inactive, which means you cannot sell property until you find a new sponsoring broker. Broker's license. Like a highlight, put an X by that one. A broker is defined as any individual partnership, LLC, corporation, or registered LLP, other than a residential leasing agent, who for another and for compensation, whether in person. All right, that's too much. Let me just tell you what it is. This is the license that all of you are going for. You are all going for your broker's license. A broker's license allows you to list, sell, and lease any type of property, any type. Industrial, commercial, residential, you have a right to do so. You must work for a sponsoring broker. You must work for a sponsoring broker. Now, in order to become a real estate broker, these are the bullets there. You must be 18 years old. These are all new, so I'm not sure what will be on the exam or not, but you have to be 18 years old to get a broker's license. You have to be a good moral character. You need the third bullet. You need a high school diploma or a GED. I would put an X by that one. You need 75 hours of classroom instruction. Now, or hours of instruction. Doesn't have to be classroom. 15 hours must be actual classroom. We more than doubled that with the hours you've been with me. We more than doubled that. But the other time comes in from doing the quizzes, watching the videos, listening to the audios. So 75 hours of classroom of instruction through videos or whatever. 15 hours either have to be a live class or live webinar. But again, we do about 38 hours approximately. You must, the next bullet, you must pass the state exam. There is a post-brokers course that's required, but you don't have to do that till April 30th, 2022. At the latest, April 30th, 2022. Need additional 45 hours before your first renewal. Now, of that 45 hours, here's what it is. There has to be 3 15-hour courses. These are the topics that they discover, and you have to take a test, but not with the state. You only take it with our school here. Now, and you have to work for a sponsoring broker. Now, managing broker's license. The second license that exists out there is a managing broker's license. You need a managing broker's license if you wanted to manage a real estate office. You need a managing broker's license. You need a managing broker's license if you want to manage property for someone else. You need a managing broker's license if you want to open up your own office and be a sponsoring broker. You must have a managing broker's license. Now, the requirements for managing broker's license. First bullet, you must be at least 20 years old. Second bullet, you must be a good moral character. You got to highlight these. Put an X by the next one. You must be licensed as a broker for at least 2 out of the last 3 years. Next bullet, you need a high school diploma or GED. You need 160, next bullet, 165 hours of education. So 120 hours are pre and post license, and then you have additional 45 hours. So let me explain this to you. let's go on. Okay. Let me clear this. Okay. To get a broker's license, that's a license you're going for right now. You need 75 hours of coursework. Of the 75 hours, 15 hours has to be classroom. I should say H for hours. Has to be an actual classroom, but we already exceed that. Now, your first renewal, which is going to happen a little bit less than 2 years, classroom or webinar, same thing. You're going to need an additional total of 45 hours of coursework, which 15 hours has to be classroom or webinar. And these are all hours. I'm sorry, I should put down hours here. Classroom or webinar. So there's 75 hours here, and there's 45 hours here, gives you 120 hours of pre-licensing, I should say, pre-licensing and post licensing. Now, in order to get a managing broker's license, you need a total of 165 hours of coursework. But you already have 120 hours completed with the brokers. So we minus the 120 hours. Now you need an additional 45 hours of coursework. Of that 45 hours of coursework, 15 hours of the 45 has to be classroom or webinar. You know what? The exam to get a managing brokers is so much easier than yours. So much easier than yours. See, for you to get your broker's license, you need to take an exam of 150 questions, multiple choice questions. The other 45 hours that you do later on, this 45 hours here, you don't test with the state, you just test with the school. But now you want to get your managing broker's license in, you know how many questions they get? They get 45 questions. That's all they get. 45 questions, multiple choice questions. They get 45 questions, and then they also get what's called 10 scenarios. And those are very simple, very, very simple. I teach managing brokers. You know how easy the managing brokers is? I think it's way too easy. So far, my pass rate on managing brokers is 100%. 100% pass rate. So you get 45 questions, multiple choice questions that I prepare them for. Then I have to do 10 scenarios. Scenarios are easy. Scenarios like this. They give you a situation, and then they have a list of questions. But you can't ask all the questions. You have to pick and choose which ones apply to it. Because some questions will give you 1 point, some might give you 2 points, some might give you 3. Or some questions will give you a -1, a -2, or a -3. I'll give you a quick example. One of the scenarios, you are hosting an open house. A buyer comes in through the open house. They give you a list of questions to ask. Some of them will give you points, some of them would take away points from you. One question might say, are you familiar with the neighborhood? That might be worth 1 point. Another question, have you been qualified by a lender? That might be worth 2 points. Another question might be, Do you mind living in a neighborhood with minorities? Well, that's going to be a -3. You understand? It's just common sense type questions. Let's talk about designated managing broker. Now, a designated managing broker, that's the person that is responsible for the supervision of all the licensees in a particular office. Now, the designated managing broker could be the sponsoring broker, who is the owner of the company, or they could assign a designated managing broker. Like in my office, the owner is the sponsoring broker. I manage this office. I run a big office, and I'm the designated managing broker for our office. I'm responsible for all 185, 187 agents we have over there. So if they do something wrong, not only could the agent lose their license, but I could lose my license, and the sponsoring broker could lose their license. It's a lot of responsibility. So now, if my owner had more than one office, he could assign a different designated managing broker for each office, or he could have assign one person to manage, to be the designated managing broker of several offices that he owns. I cannot manage an office for my current broker and then for a different sponsoring broker. I could not. So you can highlight, put X by that paragraph, and also on top of this page where it says designated managing broker's responsibility, you could put an X by that one too. We have to submit to IDFBR who the designated managing broker is. So let's go on to, well, some of the things they're responsible for. Designated managing broker's responsibility includes supervision and training of all licensees and employees associated with each assigned office, implementing the company policies, and supervision of all the sponsoring broker special accounts, the escrow monies, if we hold security deposits, whatever it might be. So you can highlight the next few paragraphs there too as well. Now, education exemptions for brokers and managing brokers. The following people are exempt from taking the classes. They still have to take the exam. Lawyers, state of Illinois, attorneys at law who've been licensed by the Illinois Supreme Court to practice law here in Illinois, they do not need to take the course. They do have to take the state exam. Now, I just want to tell you, and I've been going through stuff, and you're going to see a lot more coming up about different tricky questions that they have. I have had in my actual life classes, I would say at least a dozen, maybe 12, 14 attorneys at law, because they couldn't pass the state exam. It's tricky, and that's why they had to take the course. They're not required to, but it's, I mean, to be a lawyer, I mean, with the education that they have, they're very, very smart, but it's so tricky that they had a hard time passing the state exam. Maya, do you have the 7th edition in your book? Because it's not in a, yes, it's a 7th edition. Okay. So it's in the 8th edition. So that's why you don't have it there. So everything I said, and if you want to take a screenshot, let me lower this thing to you so you can take a screenshot of it and go back to designated managing broker. Oh, I went too far. Because that's a new law that just came out very, very recently, like in August or something. Nope, I'm not there yet. Okay, starting at the bottom of this page, 349, designated managing broker's responsibility and supervision. And on this next page, let me scroll up a little bit more. Everything I just said, and it's in there. Again, they have to assign, you have to notify IDFPR down in Springfield who the designated managing broker of the office is. And then their responsibilities are right there. So you can take a picture of that. Anybody else that might have the 7th edition. Don't worry, I will keep you. I hope I say I can't tell if I'm mispronouncing your name. Maya, I believe, I'm not sure, but I'll make sure that you and everyone else will be updated on all the current laws, okay, all the changes. Maya, thank you very much. Thank you, Maya. Okay, now, again, attorney at law is exempt from taking a class. They still have to take the state exam to get their broker's license. Then they have to wait 2 years, then take the managing broker's classes. Like I said, I had this, a law firm once hired me, it was a few years ago, a couple years ago, to go downtown and train 4 of their attorneys, 4 of them, because they want to get their broker's license, and they had a hard time passing it. So I did that for them, you know. Guess what I did though? I charged them a lawyer's fees. I charged them $400 an hour. Plus I had to pay for my parking, valet parking. I told them. They did. And they all passed. So attorneys must still take and pass the state exam. Now, here's something I don't like to tell anybody. This is the last paragraph on 350. Continue eligibility for brokers and managing brokers. Once you complete our course, you have 2 years to take the state exam. But let me tell all of you this, do not wait 2 years. Take the state exam. You already been with me for 5 weeks. It's going to be 5 weeks. Take the state exam as quickly as possible. I know what happens. You know, they take this course for 5 weeks and, you know, I want to take a break. I want to relax for a couple of months. Then I'm going to come back and take the state exam. You're not going to pass. You're not going to remember this information. So take the state exam as quickly as possible within a week or so. Please don't wait. It's bad enough there's a waiting list to get to the state exam right now too, because they fell behind when they quit testing for a while. Now, the first paragraph on this next page on 351. The broker or managing broker's license must be applied for within 1 year of passing the state exam. So once you pass the state exam, you must activate your license with a sponsoring broker within 1 year. If you don't, well, you would have to retake the test or the course. Now, the next couple lines highlight, put an X by it. If you fail the state exam 4 times, well, first of all, I'm going to get very upset at you because you're going to wreck my average. Just talk to someone. This week I had a lot of good calls from people passing the very first time. I had a call on my way here this evening, and someone told me, Sam, everything you said was right on target. The videos helped so much, and webinars helped, and I passed the first time. I got this from a lot of people, so just do everything I tell you to do. You're going to be just fine. But if you fail 4 times, you have to retake the entire course. Now, don't worry about this other stuff. After these 3 bullets, that one paragraph, it's in bold and it's underlined, so put an X next to it. I'm not going to read this because it's kind of confusing to read, but I'm going to tell you what it says. Well, it starts off with no corporation. Here's what it says. A broker or group of brokers cannot own more than 49% of any real estate company. So let's say I'm the sponsoring broker. I own a real estate company, and all of you are agents in my office, and I say to you, hey, look, if you want to invest into my company, you can. Now, whether it's one of you or all of you together cannot own or control more than 49% of the company, meaning the sponsoring broker must have controlling interest in the property. Now, this next license, residential leasing agent license. This is the third license that exists, a residential leasing agent license. Now, this is a limited scope license that just enables that person with this particular license to engage in leasing residential property only. They cannot sell residential property. They cannot sell or lease any commercial or industrial. All they could do is lease residential property. I'm not too worried about the qualifications on it. What I do want you to know is this. Let me find it. Here it is. It's the last paragraph of 351. Period in which to obtain a residential leasing agent license. You put an X by that. It says a person may engage in residential leasing activities for a period of 120 consecutive days without a license, as long as that person is pursuing their leasing agent license and they're working under the supervision of a sponsoring broker or designated broker. That's what you need to know about that. Now, requirements to take the state exam. There's a whole bunch of bullets here. I want to skip, I believe, to the 8th one. 1, 2, 3, 4, 5, 6, 7, 8. Yes. You can highlight all of them, but the 8th bullet down starts off with passing candidates. Put an X by that one. Actually, by the rest of them, starting with passing candidates. Passing candidates will be given a score report, which will let them know if they pass. They don't give you your score if you pass. You need a 75. You don't know if you got 75 or you got 100. It doesn't matter, you pass. Now, the next bullet. And again, you need X's by these last 6 bullets. Passing candidates also receive a license application, and it tells you how to apply for your license, but you cannot do it without a sponsoring broker. Next one, passing candidates have 1 year in which to apply for a license. So once you pass the state exam, you have 1 year to place your license with a sponsoring broker. Next bullet, candidates who fail the exam, they're going to give you your score and tell you what sections that you didn't do well in. Next bullet, candidates who only fail one portion, either the state or the national, they only had to retake the failed portion. So there are 2 portions, the national and the Illinois specific. You pass the national, but not the Illinois specific, then you have to reach this test on the Illinois specific. You pass the Illinois specific, but not the national, you only had to pass, retest on the national. And after 4 failures, again, well, you'll be back in the classroom. Okay. The real estate license. These first 2 bullets, you can put X's by them. After passing the state exam, a formal application for licensure needs to be made by the state, and then that's by email will be sent to IDFPR down in Springfield. Once you pass the state exam, you're given a blank sponsor card. They have to take to your sponsoring broker, your picture's on there, and it tells you how to activate your license. But again, you cannot do this without a sponsoring broker. Now, once a brokerage company has been selected by the person who passed the state exam, the sponsoring broker, and you can highlight all those 7 bullets right there. So now, once you're issued your license, you get a copy. 1 copy is kept in the broker's office. The other copy you keep with you, or they will allow you to take a photocopy, keep it on your cell phone, but it has to be produced upon request, has to be displayed upon request, but it could be on your cell phone. Now, what happens to your license when you change or leave the firms? So let's say you decide you want to quit with your sponsoring broker. What you do is you go to the IDFPR website and you terminate your relationship with your current broker. Now, once you terminate your relationship with your current broker, you cannot sell real estate anymore because you don't have a sponsoring broker. IDFPR will notify your old sponsoring broker that you left within 24 hours. But now you need a new sponsoring broker, otherwise you cannot sell. Even though you're licensed, you're not sponsored anymore. So they will notify your sponsoring broker within 24 hours. What do you do once you terminate your license? You get a new sponsoring broker, and then you apply for that license online again with your new sponsoring broker. Then you could sell real estate again. Now, let's say your new sponsor, you quit with your one sponsoring broker, you cannot sell real estate, but the other broker you're going to work for is just across the street. If it takes you 1 minute to walk across the street to reactivate your license with that new broker, then you're licensed in exactly 1 minute later. So, highlight protects by change of address, name, or business information. Anytime there's a name change, address change, email change, it is your responsibility as a broker to notify IDFPR of any change, and this has to be done within 24 hours. Let's go on to where it says non-residents and licensed by reciprocity. So I like you to highlight these bullets over here. Here's what I want you to know. The state of Illinois has reciprocity with 8 states. Now, Mia, you have 9 states. It's only 8 states. So if you go down to them, the states that we have, Nebraska, Colorado, Connecticut, Indiana, Iowa, Georgia, Wisconsin, and Florida. I think South Dakota, Mia, is the other one. You could cross that one out. We do not have reciprocity with the South Dakota anymore. I believe it was South Dakota. So you can look it up. It's on that book. Now, here's what you need to know about reciprocity. If you've been licensed in Illinois as a broker for 2 years, there are 8 states that you could go to, and all you had to do is take the state portion of the exam, and then you could be licensed in any one of those 8 states. You don't have to take the entire national. Now, say you don't want to wait for the, say you get your license here in Illinois next week, let's say, and you want to get your Wisconsin license. Well, then you have to take the entire course and the entire test. That's what you have to do. So it's not important to know what states we have reciprocity with. It's not that important. Why? I'm going to give you an example of a state exam question. So listen to my question, and I'm going to give you the answer. You've been licensed in Illinois for 2 years. Can you go to the state of Michigan and just take the state portion of Michigan and then be licensed in the state of Michigan? I want you to answer that question. Here's the question again. You've been licensed in Illinois for at least 2 years. Can you go to the state of Michigan, take the state portion in the state of Michigan, and then be licensed in that state of Michigan? This is on a state exam, by the way. The answer is, here's the answer. You got 2 no's and 2 yeses on the answer. This is on the state exam. The answer is yes, if we have reciprocity with the state of Michigan. We don't, but that's not the answer to the question. The answer is yes, if we have reciprocity with the state of Michigan. Do you understand how tricky it is? The answer is yes, if we have reciprocity with the state of Michigan, which we do not, but that's not the answer to the question. List does not change. It was the same list for 5 years, just changed this year. But that's why it's not important to know what states we have reciprocity with. The answer is yes, if we have reciprocity with that state of Michigan or whatever they might say. That's the answer to it. Yes, if we have reciprocity with that state. I hope you understand exactly what I'm telling you. Now, let's go on to licensing fees. Where it says initial fees, highlight, put an X by the second bullet. That's the only one I want you to know. To activate your broker's license with IDFPR, it's going to cost you $125. Okay. Now, I need to show you how that's broken down because they will ask some of you that question. So, what it costs you to activate your license, I'm talking about brokers, I don't care about the other ones. I've never seen those on a state exam. It's going to cost you $125, but you need to know how it's broken down. There is a processing fee. Which is $110. There is something called the recovery fund, which I'm going to talk about at the end of this chapter. Chapter 16, recovery fund, that gets $10. And then we have something called research and education. Which is $5. That makes up to $125. Occasionally, some of you are going to ask you for the breakdown, so make sure you know that. Now, let's go on to renewal fees. I want you to highlight, put an X by the second and the third paragraph. Every 2 years, a broker has to renew their license. The cost to renew your license for a broker is $150. Put an X by that one. Put an X by managing brokers. The cost for a managing broker to renew their license, $200. Know that, okay? Now, license renewal dates. I want you to highlight, put an X by the first bullet where it says broker, and the fourth bullet where it says managing broker. Now, here's what you need to know. Broker's license expire on April 30th of the even numbered years. You got to know the date and the year. Managing broker's license expire on April 30th of the odd numbered years. Here's what you need to know. You need to know that both the broker and the managing broker's license expire on April 30th. That's what you need to know. But you also need to know what year. So remember what I'm going to tell you right now. Managing brokers, we are odd. You brokers, you get even with us. They're both on April 30th, but managing brokers, we are odd. Brokers, you get even with us. Don't worry about the others. Don't worry about the others. Now, continuing education hours, brokers, they need 12 hours every 2-year renewal period. Now, you don't have to know about the electives or anything else, but they do include sexual harassment. That's actually brand new. But see, once you get your license in another week or two, you have to renew your license on April 30th, about a year and a half from now, okay? 2022, April 30th, 2022. But don't take any continuing education. Because all you need to do on your first renewal, take that 45-hour post brokers course. And you do that with our school. You don't test with the state, you only test with us. But after that, you're going to need your 12 hours every 2 years. Next bullet, managing brokers. Managing brokers, they need, oh, hold on a second. 4, 8 is 12. Yeah, 24 hours. They should have just said 24 hours on there. You know what? I gotta make a note on this because it's a little confusing. Here's what you need to know. Managing brokers need an additional 24 hours every renewal period. You need 24 hours of CE. And they tell you how it's broken down, but don't even worry about that. So, okay, so brokers, you need 12 hours every 2 years. Managing brokers, they need 24 hours of continuing that every 2 years. Oh, it mentions it over here, managing brokers. Okay, now, it's not quite clear, so I gotta let the school know. 356. All right. They say no more than 12 hours could be taken in any one day. We used to, here's what happens. Usually on the last week of April, I start putting in 12-hour days, actually 14-hour days, because I had to give them breaks. We do the 12 hours, we rent a banquet hall. I do about 350 agents a day for a whole week. We make a lot of money on that one. They all wait to the very last minute. All wait to the very last minute. Now, let's go on to, I think we're on 357. Your real estate business and the act. Your real estate business and the act. Place of business, highlight put X by that. Any sponsoring broker actively engaged in a real estate business must maintain a definite office or place of business within Illinois. Sponsoring broker must display a visible, conspicuous identification sign outside the office. So any managing sponsoring broker that opens up an office must have an actual place of business. They must have a sign that's visible from the street, which means that putting your business card next to your doorbell of your condo building does not make that a sign that's visible from the street. You got to have an actual place of business. The only exception without having a sign, if you're in an office building and you're on the company directory, you know, on the office directory in the lobby directory. Inside, the sponsoring broker must conspicuously display the branch office license that he or she sponsors. And they have to have conspicuously displayed or available all the licenses of all the licensees that work in that office. Now, when IDFPR ever walks into any real estate office, the very first thing they do is they have 1 foot inside the door and then they stop and they look around and they better make sure they can see the branch office license and all the licenses of the agents. Now, my office, we have them in the lobby. We have them all on display behind a glass case. And but we have so many. We have some of them in a binder that's on the front desk. So they have to be available. They can't be in the back in the storage room or displayed in the kitchen or the file box in the manager's office. Had to be conspicuously displayed, which means if someone came into the office, your license in my office, they should be able to go over to our wall and look to see, hey, yeah, that person's licensed before they get to your desk. Now, branch offices. Now, if a sponsoring broker wants to open a branch office, that's fine, they could. But before they open up a branch office, they must apply for and receive the branch office license. Now, last paragraph on 357, highlight put X by that. Loss of a branch office manager. The managing broker dies, or the sponsoring broker dies, or the branch office manager dies or quits IDFPR must be notified within 15 days. 15 days. Top of page 358. Employment agreements. Highlight put X by that. A licensee can only have one sponsoring broker at any given time in that state. I mean, if you're licensed in Florida and Illinois, you need a sponsoring broker for each state, but you can only work for one sponsoring broker in Illinois. And you can only perform real estate activities for that particular sponsoring broker. In turn, highlight put an X by, well, the entire paragraph, in fact. In turn, a sponsoring broker must have a written agreement with any designated managing broker, or residential leasing agent that he or she employs. Now, even in that same paragraph, the last couple of lines, it's in bold. The sponsoring broker must have a written agreement with any licensed brokers acting as a personal assistant of another broker. That I'm going to get back to in a few minutes, too. Now, this. Okay. All right, section 15-10, and you don't have to memorize the section numbers, but it states this, that the relationship with consumers, by saying that licensees shall be considered to be representing the consumer they're working with as a designated agent for that consumer, unless there's a written agreement specifying for a different relationship. Now, replacing common law. We have no common law here in Illinois. Instead, what we have is called statutory law. You can highlight these bullets underneath statutory law. I did this once before, but I think it's important enough for me to do it again. So, real estate transactions. In a real estate transaction, of course, there's a seller. I already did this for you once, but it's important, and that's why I want to do it again. And a buyer. You're the seller of the property. You hired me to list your property. I become your listing agent. As your listing agent, I have fiduciary duties to you. You become my client. As my client, as I said, I have my fiduciary duties to you. Buyer wants to buy a property. They hire an agent to help them find a property. Since this is the agent that sells the property, we call that person the selling agent. The buyer to the selling agent is their client. Now, this agent brings this buyer to come by and see your property. As soon as they do, me as your listing agent, I develop a relationship with this buyer. The buyer becomes my customer. I don't represent the customer. I represent you. You as a seller, you develop a relationship with the selling agent. You become their customer. The client-customer relationship is this. You work for the client and with the customer. That's statutory law. That's what we have here in Illinois. Now, you can go over all these bullets over here. These are your fiduciary duties, statutory duties. I talked about those before. Remember, cold AC, care, obedience, loyalty, accountability, disclosure, confidentiality. Now, after that first set of bullets, this line and a half says, the act also clarifies certain misunderstood situations that occur when one is an agent. Under the act, the following applies. As those three bullets you can highlight. It is considered reasonable to show available properties to various prospects without being viewed as breaching a duty to a given client. Let me explain that. I have your home listed for sale. I have a buyer that's interested in seeing your home. Not only do I show them your home, I show them other homes that are for sale. I'm not breaching my fiduciary duties to you. The next bullet, a licensee must provide written disclosure to all clients to whom the licensee is preparing or making contemporaneous offers. Contemporaneous offers is this. I have two buyers interested in buying the same property. I am allowed to work with both buyers. I cannot tell the first buyer what the second buyer is offering. I cannot tell the second buyer what the first buyer is offering. And then it says here, the third bullet, it's not considered a conflict for buyer's agent to show homes where the commission is based on the ultimate sale price. In other words, higher price means higher commission. Okay, you could afford 300,000. There's nothing wrong with me showing you homes at 300,000. I don't have to show you homes at 200. I mean, if you want to, that's fine. That's what that means. Oh, a couple more bullets. I didn't see that. Unless the licensee knew or should have known the information was false, we are not considered responsible or liable for false information passed on to us. But remember, we are responsible for things we did know of or things we should have known of. And then licensee remains responsible under common law for negligent or fraudulent misrepresentation of a material fact. So we are responsible for things we didn't know of or should have known of. Now, section 15-25, it says licensee treatment of customers. A licensee shall treat all customers honestly. I have to treat all customers honestly. I have no fiduciary duties to them. I have that to my client. The next line, 15-40, clearly states compensation does not determine agency, does not determine who pay your commission. You represent the person you're working with regardless of compensation. So, and I did this once, I'm gonna do it again. Not always, but generally, seller is the one that pays the commission. The entire commission always goes to the listing office first. Now they keep a portion of commission and they share what we call co-op with the selling office. Now, the portion that stayed with the listing office over here, there's a split between the sponsoring broker of the listing office and the broker. The portion that went to the selling office, there's a split between the sponsoring broker of the selling office and the broker. Now, here's what happened. The broker of the selling office, the sponsoring broker of the selling office, the broker of the listing office, and the sponsoring broker of the listing office all got paid by the seller, not directly, because the licensee can only get paid from their sponsoring broker only. Again, it does not matter who pays your commission. You represent the person you're working with, regardless of compensation. Compensation does not determine agency. Sorry. Okay. Now, dual agency. Remember I talked about dual agency before. Dual agency means you're working with both the buyer and the seller in the same transaction. Dual agency is allowed here in the state of Illinois, as long as you get signed written permission by both the buyer and the seller to work as a dual agent. And if you are working as a dual agent, which agents like because they get twice as much commission, but neither party is getting any representation at all, all you're doing is working as a facilitator. Now, remember, you cannot be a dual agent on any property that you have any interest in. You cannot. Designated agency, highlight, put an X by that one. Oh, I don't know if I told you, but X by dual agency also by those couple lines. Designated agency creates single agency. See, remember, all the buyers, all the sellers always belong to the sponsoring broker. If I'm your sponsoring broker, you're a broker in my office, you go out there and get a listing, I sign you as a designated agent to that seller, which allows anyone else in my office to come in, and I'm not involved in a dual agency situation. Designated agency creates single agency where you're only representing one party only. The buyer only or the seller only. We have no sub-agency in Illinois. Let me briefly explain it. I don't want to get you confused, but let me briefly explain what sub-agency is. Now, the seller over here paid a commission. The entire commission goes to the listing office, but there's a split between the sponsoring broker here and the sponsoring broker of the listing office and the broker of the listing office. Then there's a split between the sponsoring broker of the selling office and the broker of the selling office. Since all the brokers and all the sponsoring brokers got paid for the director by the seller, that means that everyone works for the seller. This listing agent is the agent of the seller. The selling agent is the sub-agent. Everyone works for the seller, but we don't have sub-agency. What we have is designated agents. Statutory law. Statutory law means you represent the person you're working with, regardless of compensation. Compensation does not determine agency. Now, disclosure. What must be disclosed? Material facts. A material fact is something that will cause someone to make a decision or not make a decision as a material fact. Known latent defects. Now, a latent defect is a hidden structural defect. We are not responsible for a latent defect. We are responsible for a known latent defect. Agency relationship, which includes designated agency, due agency, lack of agency, and then compensation sources. Now, what's not required? HIV or AIDS. People with AIDS are protected under that 1988 amendment under the Federal Fair Housing Law. Cannot discriminate against people with AIDS. That falls under mental or physical disability. I have a question here. Here's a good question. Since you cannot serve as a due agent, the transaction that you have an interest in, the agent's not able to sell the property as for sale by owner. Well, yes, you can sell property for sale by owner. The person that's going to buy the property, they need to have an agent, or you have to make sure that you have them sign what's called a non-agency disclosure form. It's called non-agency disclosure form, which means that, look, you're strictly on your own. I cannot represent you. Anything you tell me, I'm going to just take that as fact. So you have to have them sign a non-agency disclosure form. That's what you have to do. You're quite welcome. It's a good question, too, by the way. Now, let's go on to I think handling clients' funds is what I need. Yes. So on top of page 361, The first two lines, I know I said this about 4 or 5 times already. You're going to hear it probably a couple more times because it's going to be on the state exam. The Act holds that clients must be made aware of compensation, source of compensation of sponsoring broker's policy on sharing a commission with cooperating brokers. So how much of a commission I'm charging you, and who's going to be paying that commission, and how much of that I'm going to share with cooperating broker must be disclosed. Handling clients' funds. Okay, again, whenever you handle money or property that belongs to others, you have to be very, very careful. You sell a property, you have earnest money. Your job as a licensed broker, get that money over to your sponsoring broker immediately, because your sponsoring broker must deposit that money within 24 hours of the contract acceptance. Now, the next line underneath there, the Act states that the sponsoring broker escrow account is to be non-interest bearing account. All escrow funds must be deposited in a non-interest bearing account. In case that bank goes bankrupt, non-interest accounts are paid first. There's money left over, then it goes to interest bearing accounts. The next paragraph, put X by that, sponsoring broker must maintain and deposit in a special account separate and apart from the broker's personal or other business account all escrow monies belonging to others. Now, the sponsoring broker could have a separate account for each escrow account that they have, or they could put in one big account. In fact, a couple paragraphs down, there it is, one line by itself. The Act does not limit the number of escrow accounts that one sponsoring broker may maintain. They can have several, or they can have one big account. If they have one big account, then they got to be careful that they use very sound accounting principles with their records. Couple lines down where it says commingling and conversion. We already talked about that. Commingling. Remember, commingling means mixing. Mixing escrow funds with the broker's personal or business funds is commingling. Number one reason why sponsoring brokers lose their license. Commingling means mixing. Conversion means stealing. Okay. Now, disputes over disbursement of escrow funds. Highlight, put an X by that one. Now, if we're holding escrow money for both the buyer and the seller, and there's a dispute, say the seller says, look, I was buying this property contingent upon me getting the mortgage. I wasn't able to get the mortgage. I give the proper notice. I'm entitled to get the earnest money back. But we cannot release the earnest money unless we have signed written permission by all parties to the contract. If the seller refuses to sign off on that, we have to try to resolve the issue. If they can't, we can't release it until they both sign the checks, the earnest money release form. Now, if they can't get into agreement, we cannot hold on to the money forever. They can get into agreement within 6 months. We have a right to turn that money over to the state treasurer, and good luck trying to get the money back from the state of Illinois once it goes there. Escrow account records. Now, I want you to highlight, put X by that paragraph. Each sponsoring broker who accepts earnest money shall maintain in his or her place of business a bookkeeping system in accordance with sound accounting principles. And they must be kept at the following escrow records. Highlight, put an X by those 2 lines, journal. A journal. A journal must be maintained for each escrow account. The journal shall show the chronological sequence in which funds are received and dispersed. Make sure, though, here I'm going to give you a warning. We're going to go on break in about 10 minutes, but I want to give you a warning right now. Make sure you stay to the end of the class, because I'm going to give you a lot of questions. I'm going to ask you a bunch of questions. Some of them are tricky questions. So I expect all of you who are here to answer them. Now, let's go on to a ledger. Highlight, put an X by that little paragraph, ledger. A ledger shall be maintained for each transaction. The ledger shall show the receipt and disbursement of funds affecting a single particular transaction between a buyer and a seller or the landlord and a tenant. Let's go on to monthly reconciliation statements. Highlight the first two lines, you put X by it. Each sponsoring broker shall reconcile within 10 days of the receipt of the monthly bank statement for the escrow account. And the first paragraph on 363 says, put X by that first paragraph. Each sponsoring broker shall maintain a master escrow account log identifying all escrow bank account numbers and the name and address of the bank where the escrow accounts are located. So that's everything about that. Now, let's skip down a couple of paragraphs. Let's talk about unlicensed assistants. Now, okay, top producing agent, I repeat this again, they need some help. There are two types of people they can hire, a licensed personal assistant or an unlicensed personal assistant. Now, again, a licensed personal assistant, it's not a separate license. Someone that has a broker's license, but rather than working directly for a broker, they're working for another, instead of working directly for a sponsoring broker, they're working for a broker. So again, let me give you this example. I know you heard it, but I want to repeat it. You're a licensed broker working for a sponsoring broker. You're very, very busy, need some help. You hire me. I'm a licensed broker. Now, since I'm licensed, I could do anything you could do. Anything you could do. Show property, host an open house, interpret contracts, and negotiate fees. I could do everything you could do. Now, ways you could pay me. You could pay me hourly. You could pay me salary. You could pay me a % of the commission if you want. But you can't pay me direct because I'm licensed. What happens? You have to pay our sponsoring broker who then pays me. I still need an ICA, independent contractors agreement with the sponsoring broker. So that's if I'm licensed. Now, what if I'm unlicensed working for you? You're a broker working for a sponsoring broker. You hire me, I'm not licensed. Since I'm not licensed, I'm limited to doing clerical type work. Answer the phone, take messages, file papers, assemble documents, put up the sign, make a flyer, that kind of stuff. Now, what's important, more important, is what I cannot do if I'm not licensed. I cannot show property, cannot host the open house, cannot interpret contracts and negotiate fees or anything else. I cannot do anything that a license is required. Now, since I'm unlicensed, however you pay me, it can only be hourly or wage. It cannot be a % of the commission. It cannot be. But you can pay me directly because I'm not licensed. Question is, if not licensed, can they call to schedule a showing? Yes, they can. They can't show up at the property with the keys or anything else or walk them through it. That they cannot do. Just by phone, set up the appointment. Okay. Now, advertising regulations. Oh, I got another question here. If licensed, they get paid through the sponsoring broker. Yes, sponsoring broker. Unlicensed, they could get paid directly by the broker that hired them. Now, advertising, which includes everything, social media, digital forums, everything. Now, a sponsoring broker must include his or her name and franchise affiliation in all advertising. The sponsoring broker's name, this is not quite right either. I got clear. It says it there, but I want to make sure. Page 363, advertising. Sorry, I'm taking a couple notes because this is the newest 6th edition, and of course, there's always typos. So the sponsoring broker's name shall, this is, put an X by this one. Sponsoring broker's name shall be at least equal in size or larger than the team members or of that individual license. I think there's going to be an example of that. I think so. And I'll explain it to you. Blind ads are prohibited. No such thing as blind ads. Now, a blind ad, here, let me give you an example of a blind ad. I think I might have done this already, but here's a blind ad. For sale. 4-bedroom, 3-bath. I'm sorry if I had to repeat things because I'm doing 1, 2, well, let's see, 1, 2, 3 classes at the same time right now. 4-bedroom, 3-bath, located in Jefferson Park. Call Sam at this number. That's a blind ad. I must use the broker's business name in all ads. It is better to repeat than forget. Just want to make sure. So, yes, you're right, Rebecca. I must use the broker's business name in all ads. I don't care. On my website and everything else, I must use the broker's business name in all the ads. The broker's business name must be the same as mine or greater than mine. Blind advertising includes electronic ads, websites, everything. Now, designated managing brokers must advertise as the designated managing broker. All other managing brokers can't advertise as managing brokers. That's new. So, but that's allowed. Towards the bottom here of page 363 states that all ads prepared by licensees should at least include the property for sale, the licensee's name, the company's name as registered with the department, the city, the state of the and the area too. All their ads, they have to have the licensee's name, the company's name as well. Now, a licensee must put X's by these 5 bullets here. Never advertise only in his or her name. Got to use a broker's business name. Always include the firm's name and address, which has to be the same size or larger as the agent's name. Never advertise another sponsoring broker's listing without written permission, and always keep advertisement up to date and clear, and never create ads containing inherent misleading terms like company, realty, real estate agent, etc. You know, I can't put Sam Zakarian company or Sam Zakarian properties or anything else like that. I could say Sam Zakarian, that's it, and the company I work for. I think actually there was a different ad. It was there was an example on a different chapter. I just remembered there was. Now, social media and text. Social media is a great way to get your name out there to thousands of people, which is one push of a button. That's fine too. Whatever you happen to use, whatever platforms you happen to use, that's fine for any of your showings, listings, open houses, closings, anything else. You should include your activity. You should be doing that once you're licensed. Let everyone know what you're doing. You had a showing, you had a contract accepted, you had a closing. People like to see people being active. Now, the next section. A licensee's advertising by way of internet or other forms of electronic media are forbidden to, and you can highlight these next 5 bullets, and you can go over those on your own, nothing tricky about those. Or the next 7 bullets, sorry. Internet advertising situations, the rules do not allow advertising. These next two bullets you can highlight. Advertising a property that's subject to an exclusive listing agreement with a sponsoring broker other than your own sponsoring broker without the written permission of the other sponsoring broker, and failing to remove advertising of a listed property within a reasonable time, usually 48 hours once it sells and once it closes. I'm sorry. Now, put an X by where it says painting a true picture. Put an X by that one. You got to be truthful in your advertising. You got to paint a true picture, which means there's, I do training webinars. And let me tell you some of the fines that agents have. Because I serve on I told you I serve on the Chicago Association of Realtors as a judge to hear these cases, and these are some things that came up, and we just had to find these people. People sometimes, painting a true picture, what they do is they get very creative, I should say, and Photoshop their pictures of the house. One example was there was a house, and right next to the house, there was one of those big, huge white water towers, that was right next to the house. But the agent photoshopped that tower out of there. So they looked at it and says, it looked good. Was on a picture, looked good. So when they pulled up, here's this big old, it was rusty too, this rusty, huge water tank owned by the city right next to the property. And obviously they didn't put that overnight. They got fined for that one. There was another agent that had a picture of a condo, and they showed a picture looking out the window, and you saw trees and sky and beautiful. There was nothing there. It was another building. All you could do is look at another brick building. One house, they advertised, they had a fire plug in front of the house, but they photoshopped the fire plug out. They got fined for that one too. There was another guy that did something. It had a single family home, a one-story home, but it has steps going up from the main floor to nothing because there was no second floor. So, okay, let's skip down to selling your own property. You can highlight, put an X by the next 3 paragraphs. If you're going to do a for sale by owner, that's fine. On your for sale by owner sign, your website, your flyers, everything else that you do, you have to put down agent, owner, broker, own. We have more knowledge than the general public, and we must make them aware of that. So it says after that, licensee must always disclose agent owned and place agent owned on the home sign if it's a for sale by owner. Now, if you list your home that you own with your sponsoring broker and use the company sign, you do not have to put agent owned on the sign, but it has to be on the listing information sheet and all the advertisement that it's agent owned. Okay, compensation and business practice, Article 10. All these bullets here, I want you to highlight and put an X by all of them. I'm going to read these all out to you. I'm going to read every single one of them. So again, I'm just using these as references, these section numbers. You don't have to memorize them, just using them for reference. So under compensation and business practice, Article 10, Section 10-5, a licensee may not receive compensation from anyone other than his or her sponsoring broker. Second bullet, sponsoring brokers may directly compensate other sponsoring brokers like in a co-op commission arrangement. Next bullet, Section 10-10. Disclosure of compensation is a significant issue. The Act holds, and here it is again, clients must be made aware of compensation, source of compensation, and the sponsoring broker's policy on sharing commission with cooperating sponsoring brokers. Next bullet. If compensation is being issued to an agent from both the buyer and the seller in the same transaction, this also has to be disclosed in writing. You don't have to get their permission, just have to let them know. You hired me to help you find a property. You want something very unusual. You're willing to pay me a commission. I happen to find something that fits your needs, and it happens to be listed by another company, and they're offering a co-op fee. I could collect a commission from both the buyer and the seller. Also, in the same paragraph, any third-party compensation must also be disclosed. So if I'm getting paid anything to refer you to another company, a loan officer, a lawyer, a title company, whatever, I'm getting a kickback, I have to disclose that too. Next bullet. If a licensee refers a client to service which a licensee has greater than 1% interest, that also must be disclosed. I want you to use this construction company. By the way, I own this construction company. Section 10-15. It is illegal to compensate an unlicensed person or anyone else being held in violation of the act. The next bullet. X is by all of these, by the way. To sue for a commission in Illinois, one must be a licensed real estate sponsoring broker. Why? Buyers and sellers always belong to the sponsoring broker. Funds from sellers or buyers must always go through the sponsoring broker because only he or she is the one that issues compensation to brokers, managing brokers, residential leasing agents, or licensed brokers. Next bullet. No licensee may pay referral fee to an unlicensed person who's not a principal of the transaction. You cannot pay anyone that's unlicensed any part of your commission unless they're the buyer or the seller. They're part of that transaction. Next bullet, section 10-15. States that licensees may offer cash gifts, prizes, awards, coupons, etc., if not prohibited by law. The next bullet. Additionally, it is perfectly legal to share commission compensation with the principal, the buyer or the seller, in any given transaction. Next bullet. It is now legal for a sponsoring broker to pay a corporation set up by the licensee. So the commission they earn could go to this corporation, but you still have to sell under your own name. Then the next bullet, the law allows formation of an entity to receive compensation from the sponsoring broker, where the licensee is the sole owner of that entity, that corporation. Now, disciplinary provision and loss of license. These next couple pages here, they have several ways that you can lose your license. You violate any of these, what could happen to you? There's 5 bullets there. 1, they could refuse to issue or renew any license. They could suspend or revoke a license. I'll put X's by all 5 of these as well. They could censure or reprimand a license. They could place a licensee on probation, but put 2 X's on this one. They can impose a civil penalty not to exceed over $25,000 for any one or combination of causes. So, by the way, IDFPR does have a right to investigate anyone that's licensed or unlicensed, and even anyone that's unlicensed that practices real estate, they could also be fined up to $25,000. Now, causes for discipline. Department may take disciplinary action against all licensees for any one cause or combination of cause. Specifically, a licensee may be subject to disciplinary action or fines if the licensee. Now, in these next couple pages, I have dozens of ways you can lose your license. Now, most of these are for sponsoring brokers, but you need to be aware of them, okay? So this first bullet, I'm gonna like you to highlight all of them. Some of them, I'm gonna have you put an X by because they show up a little bit more than others. So the first bullet, making a false or fraudulent representation and attempting to obtain or renew a license, that you lied, that you did complete your continuing ed, whatever it might be. Next bullet. If you've been convicted of a felony or a crime involving dishonesty, fraud, larceny, or embezzlement, they can refuse to issue or renew your license. Next bullet. If you're unable to practice the profession with reasonable judgment, skill, or safety as a result of a physical illness, that's a new one. Next bullet. You practice as a licensee in a retail establishment from an office or desk that's not separate from the main retail business. You cannot have a real estate office in a bank. You cannot have it in a department store. Put an X by this one. If you've been subject to disciplinary action by another state, district of Columbia, territory, foreign nation, government agency, or any other entity authorized to impose discipline, if at least one of the grounds for that discipline is the same or equivalent to for a cause for discipline in Illinois. Meaning this, you're licensed in the state of Virginia and you did something wrong and you lost your real estate license in Virginia. If the reason why you lost your license in the state of Virginia is the same reason why you can lose your license here in Illinois, they could refuse to issue your license. Next bullet. If you engage in any real estate brokerage without a license, expired or inactive license. Next, if you attempt to subvert or cheat on the licensing exam or assist anyone else in doing so, you can put an X by that one. Now, when you take the state exam, you are being videotaped when you take the state exam. Just want to let you know the person next to you does not have the same exam as you. All the questions are jumbled up. Number 45 to one person is not the same question that you might have for question number 45. If you're taking a test and someone asks you a question, you tell them, don't talk to you. Now, if they bother you again and ask you another question, go and tell the proctor that this guy's asking me questions. Otherwise, both of you will never get your license. Next, advertising that's inaccurate, misleading, or contrary to the provision of the Act. Now, it says here, a licensee is also subject to disciplinary action if the licensee is found guilty of any of the following activities. Next bullet, making substantial misrepresentation or untruthful advertising, meaning advertising a property that doesn't exist just to drive business to your website, you can't. Making any false promise to influence, persuade, or induce. I remember I was up in the front in my office and I see this agent talking to his client. I overhear the conversation. Here's what my agent said to that client. Guaranteed, if you buy this property today, by next year, it's going to go up by 20%. That's what my agent told this client of his. So when he got off the phone, I says, look, you can't say that. You don't know what's going to happen with real estate. And by the way, that happened, he said this just before COVID. So here's what happened. Here's what he said to me. You know what, Sam? You don't know what you're talking about. I says, okay, let me tell you something. If I ever hear that you say this to any client, whether it's true or not, you are out of this office. I'm not packing your stuff. I'm going to pick up everything off your desk and I'm going to throw it on a curb on the street. So I believe me, he did not do that again. Next, pursuing a continuing fragrant course of misrepresentation or making false promises through licensees, employees, agents, advertising, or otherwise. Next, using any misleading or untruthful advertising. Put an X by this next one. Using any trade name or insignia in a membership and any real estate organization for which a licensee is not a member. Put an X by this next one. Acting for more than one party in a transaction without providing written agency disclosure. Talking about dual agency. Next bullet, representing or attempting to represent the broker, other than your sponsoring broker. Apparently, someone must have done this. On the next page, failing to account for, now again, a lot of this is geared towards sponsoring brokers, but you need to be aware of these. Failing to account for any monies or documents belonging to others that come in the licensee's possession. Again, you handle money, earnest money checks. You handle documents, title reports, deeds. You handle keys to someone's house. When you handle money or you handle property that belongs to others, you better be very, very careful handling someone else's property. Again, this next one is for sponsoring brokers. A lot of them are, but you need to be aware of it. Failing to properly maintain and deposit escrow monies in a separate account. That's what your sponsoring broker does. Next, failing to make all escrow records maintained in connection with the practice of real estate available during normal business hours within 24 hours of the submitted request. Remember, IDFPR can walk into any real estate office without any notice. They have to have 2 years worth of records. With a 24-hour notice, the next bullet, you could put an X by that one, they could go back 5 years. Now, they could use electronically or hard copy, it doesn't matter. But if you're doing it electronically, you better back up your computer on a regular basis. Next bullet, failing to furnish on request copies of all documents relating to real estate transactions to all parties executing them. 24 hours is the number. Whenever anybody signs any document, they need a copy of what they signed within 24 hours. Next, failure of a sponsoring broker to provide appropriate license documents, termination information in a timely way. Next, engaging in dishonorable, unethical, or unprofessional conduct of a character to likely deceive, defraud, or harm the public. Put an X by the next one, commingling the money or property of others with one's own. This next one, we already did it. It's duplicated in there for some reason. So you can skip that one. Next bullet, employing any person on a purely temporary single deal basis as a means of evading the law regarding illegal payment of fees to non-licensees. Next, permitting the use of one's managing broker's license by another person in order to operate a real estate office. There was a time back when the market was hot in the early 2000, 2003, 4, 5, and 6. I had so many people approach me, want to take my managing broker's license so they can open up a real estate office to sell real estate without me being involved in it. Can't do that. Next, engaging in any dishonest dealings, whether specifically mentioned by the act or not. Put an X by the next one. Displaying a for sale or for rent sign on any property or advertising in any fashion without the written consent of the owner. Now, to put a for sale or for rent sign, to advertise in a multiple listing on websites, to host an open house, you must have signed written permission by the owner. It is all included in the listing agreement. Put an X by the next one. Failing to provide information requested within 30 days of the request as related to audits or complaints made against the licensee based on the act. If IDFPR ever contact you and they want some information, you need to respond. And the best thing you can do, respond right away. Put an X by the next one. Utilizing blind advertising. Again, you got to use a broker's business name in all ads. Next one, offering a improperly constructed guaranteed sales plan. Actually, I'm going to talk about that in a couple of minutes in more detail. Next bullet, intending to promote racial or religious segregation by use of actions or words or behaving or speaking in such a way as to discourage integration. Put an X by the next one, violating the Illinois Human Rights Act. Illinois Human Rights Act is Illinois' version of the federal fair housing law. Put an X by the next bullet. Inducing any individual to break out of an existing contract, enter into a new one, whether a sales contract or a listing contract. This has been going on, popping up a little bit more lately, getting multiple offers, sells in a few days. Another agent from a company will say, look, I got a client very interested. If you break that agreement, that sales contract on your listing with the other agent now, let me bring in my offer. Well, I'll give you $3,000. Yeah, really? Just for mentioning that to me, you could get fined 25,000. X by the next one, negotiating directly with the client of another agent. I have your home listed for sale. Anyone that has any offers, they must go through me. Next bullet, acting as an attorney in the same transaction, which one acts as a real estate agent. You cannot be a lawyer and a real estate agent in the same transaction. You cannot be an appraiser and a real estate agent in the same transaction. But you are allowed to be a mortgage loan officer and a real estate agent in the same transaction. Next bullet is if merchandise or services are advertised for free, any conditions or obligations necessary for receiving the merchandise or services must appear in the same ad or offer, meaning this. List your home with me, and I'll give you a 80-inch flat screen TV. Well, there's a condition of you getting that 80-inch flat screen TV. Not only must you list your home with me, it must be listed at over $500,000, must sell and close for cash within 30 days. Otherwise, you don't get the TV. You understand? If there's any conditions on receiving the merchandise, they have to be in the same ad. Next, disregarding or violating any provision of the Land Sales Registration Act or the Timeshare Act. The Timeshare Act, anyone that sells any timeshares in Illinois, they must register with IDFPR down in Springfield. Land Sales Registration Act, Interstate Land Sales Registration Act. Anyone that buys vacant land located outside of their own state, they must get a property report at the signing of the contract. If they get the property report at the signing of the contract, they still have 7 days to cancel the contract and get their money back. If they don't get the report at the signing of the contract, they have 2 years to get their money back. Violating a disciplinary order issued by IDFPR. Next bullet, paying or failing to disclose compensation that violates the act, like taking cash without going through your broker. Next, disregarding or violating any provision of this act or the published rules or any regulations promulgated to enforce the act. Next bullet, failing to provide minimum services under the exclusive brokerage agreement. Again, minimum services, present any and all offers, communications, memos in a timely fashion. Next, violating the terms of a disciplinary order issued by the department. Put an X by this one. Forcing any party to a transaction to compensate the licensee as a requirement for releasing earnest money. Let's say a buyer put up $10,000 in earnest money, and he's buying a property subject to them getting a mortgage. He did not get the mortgage, gave the proper notice, entitled to his earnest money back. But the agent says, look, I put a lot of time in here. I'm not going to release that $10,000 to you unless you give me $2,000 for my time that I wasted. You cannot do that. This is a fairly new one too. Habitual use or addiction to alcohol, narcotics, stimulants, or any other chemical agent that results in a licensee's inability to practice with skill and safety. I don't know where this office is. There is an office somewhere in the far northwest side of the city of Chicago. I'm not quite sure where it's at. Haven't found it yet. They must have, I don't know what they have over there. Just that the agents from that office, they show up at a showing and they're drunk. They got their martini glass. They lost their shoes. I don't know where their shoes are at. They're barefoot. Their pantyhose are torn. I don't know what it is. That must be one hell of an office. I like to find out I like to work there maybe. What's that? Sounds like a fun office. Can't do it though. Next, failure to disclose the licensee status on a multiple listing service data form that's accessible to the public if the licensee has any ownership interest in the property. Now, okay, non-payment of child support. If you are behind on child support in Illinois, more than 30 days behind, they can refuse to issue your license. If you are behind on Illinois state revenue taxes, they don't care about the IRS, but Illinois, they do. They can refuse to issue your license. If you are behind on Illinois student loans, only Illinois student loans, they can refuse to issue your license. Put an X by this next one, discrimination. If a licensee is found guilty of discrimination, automatically their license must be suspended or revoked automatically. Guaranteed sales plan. You can highlight this next little paragraph. Highlight this next paragraph on the next page as well on 370. You got highlight 1, 2, 3, 4, 5, 6 bullets here. So let me tell you what that states. You offer a guaranteed sales plan. A guaranteed sales plan is this. If I don't sell your home, I will buy it. Well, all the terms of that must be in writing. Now, usually how they work, because there used to be a company, they're not around, I don't see them, not at least not in Chicagoland area, it's called ERA. If we don't sell your home, we will buy it. Their plan was this. They do an appraisal on the property. You have to list with them for a year. If they don't sell, they will buy it. Not at your price, at the appraisal price, but not at the appraisal price. 30% less than the appraisal price. Now, if you're going to offer a guaranteed sales plan, that's fine. You got to market the property as you would any other property. Don't buy it until the listing agreement term ends. And you got to show proof that you have funds available to buy it. Let's say, if I don't sell your home, I will buy it. It's an $800,000 property. I must show the owner I have $800,000 in the bank. Otherwise, I cannot offer that. But if I don't sell your home, I will buy it to 5 different sellers. And each of those properties are 800,000. 5 sellers times 800,000 is $4 million. I got to show I have $4 million in the bank. Otherwise, I cannot do that. Now, the rest of this, you go over this on your own. I'm going to look at this. This next page, you can go over this on your own. This next page, you can go over this on your own. Let's go to page 373, Real Estate Recovery Fund. I want you to highlight, put an X by the first paragraph, highlight the bullets underneath, all of them. Put an X by reimbursement from the recovery fund. Put an X by the next paragraph, the procedure for the recovery fund. Put an X by that one. Put an X by the next paragraph where it says the fund will pay out a maximum sum of $25,000. Put an X by the next paragraph if the licensee wishes to have their license reinstated. Put an X by that one. Skip down a couple paragraphs. Put an X by where it says collection from the recovery fund. And the last paragraph of 373, highlight, put an X by that one where it says that the claimant recovers. And let's see. Highlight, put an X by the second paragraph where it says claimant to obtain recovery from the fund. Put an X by the next paragraph when the judgment amount is paid from the recovery fund. And put an X where it says fund losses held. against the license. Pretty much you got to put an X by everything, and I'm going to explain this to you. And put an X where it says statute of limitations, and put an X by financing it. So pretty much, starting from the recovery fund, those last 2 pages, you got to put X's by all of it. Now, let me explain the recovery fund to you. Anyone that's been aggrieved by a real estate licensee might be able to collect money from the recovery fund. Here's what you need to know. You can only collect actual money lost. No pain and suffering. Gee, you didn't get the house you want because of the actions of a real estate agent, and your spouse is mad at you and made you sleep on a couch for the next 3 weeks. Guess what? Too bad. You get nothing for that. You can only get actual money lost. Now, here's what else you need to know. The maximum you could get for any one act cannot exceed more than $25,000. Total payout against any one licensee can never exceed $100,000. So let me give you some questions that I expect pretty much every single one of you will see. Here's what it is. You listed your home with me. On day 1, I did something wrong, and you lost $150. Day 2, day 2, I did something else wrong. Because of my actions, you lost $1,500. Day 3, I did something else wrong. You lost $150,000. Day 4, I did something else wrong. You lost $350,000. Day 5, I did something else wrong. Because of my actions, you lost $15,000. So, my question to you, which is off the state exam, I need all of you to tell me for day 1, what's the maximum I could collect? Day 2, the maximum I could collect. Well, let's do one at a time. Day 1, you lost $150. What is the maximum you could collect for that one act that I did on day 1? State exam question. State exam question. You lost $150. So what's the maximum you could collect from the recovery fund? Give you another moment. I'm going to ask you this on all of them, by the way. The answer is, on the state exam, $150. You lost $150. All you could collect is what you actually lost. What's the maximum you could collect on day 2? Day 2, the maximum you could collect, 1,500. That's what you lost. Day 3 was the maximum you could collect on that one. $25,000 is correct. Any one act, you cannot collect more than $25,000 for any one act. Day 4 was the maximum you could collect on day 4. You lost $350. $25,000. Day 5 was the maximum you could collect. $15,000 is correct. This is on the state exam. Let me clear some of this out for you. You're lost. Okay, I'm going to explain this to you, Shanice. Just stay with me. I'm going to explain it to you. All right. This one is 15,000. So, Shanice, you listed your home with me. First of all, from the recovery fund, you can only collect what actual money you lost to a maximum of 25,000 for any one act, any one thing I did wrong. Total payout against the licensee would never exceed $100,000. So listen, you listed your home with me. I did something wrong. Because of what I did, you lost $150 here. So the maximum you're going to be able to collect is $150. Day 2, I did something else wrong. Did one thing wrong there. You lost $1,500 there. So the maximum you're going to collect is $1,500. Day 3, I did something else wrong. One thing I did wrong. You lost, I don't know what I did, but you lost $150,000. But the maximum you could get for any one act is $25,000. So that's all you could collect for that. Day 4, I did something else wrong. And look, you lost $350,000. But again, the maximum you could collect for any one act is $25,000. Day 5, you lost $15,000 because of what I did. So the maximum you could collect is $15,000. You can only collect actual money lost. But to a maximum of any, you got it. Okay. All right. I know I would just take this and I know you will get it. Okay. Now look what happened. Because of my actions, you lost 3, 4, 5, over 516,000, almost 517,000. All you're able to collect is 6,700 or something. Okay, as long as you got it, you understand that. Now, here's something else about the recovery fund. In order to collect from the recovery fund, in order for a consumer to collect from the recovery fund, what they have to do, they have to take the agent to court, win the court case, attach the personal assets of that agent, allow the agent to exhaust all its appeals, and then, and only then, can they collect from the recovery fund. So again, in order to collect from the recovery fund, the agent, the consumer must take that agent to court, sue him in court, win the court case, attach the personal assets of that agent, allow the agent to exhaust all its appeals, and then and only then can they collect from the recovery fund. So let me give you a hint. They never pay out. In their entire history, they've only paid out one time. They never paid out. normally never pay out. Because to meet those restrictions, it's almost impossible. But that's what the law is. Now, and that is the end of chapter 16.